Well, hi, I'm John Dearie, and thank you very much for joining us for this session of our face-to-face attorney interviews, where we want to discuss topics of our practice that you are interested in. And today is a very, very important one, because I think of all of the topical areas that we get questions about, I think people ask more about medical malpractice, feeling that a relative or a friend of theirs had some experience with a doctor or a hospital, and as a result of it felt that something wasn't quite right and felt that they may have a medical malpractice. But that needs to be discussed, and you'll hear from a person that is extremely unique, because while we're talking about a very a prominent and excellent trial lawyer, you should also know he is a doctor also. There's not too many doctors and lawyers, and especially someone that is so knowledgeable about the practice of medical malpractice. And I'm delighted to welcome Elliot Wolf from the firm of Wolf and Furman, who we work in co-counsel with on medical malpractice cases. Elliot, so delighted and appreciate you being here.
Thanks for having me, John.
Let's get to the most fundamental question, one of, I think, considerable confusion for most people, and that is, how do you define the term medical malpractice and the practice of medical malpractice? What does that mean?
Okay. There are basically two aspects to every malpractice case. The first one is, was there a deviation from good and accepted standards of care? To put that into simple English, was something done improperly or wrong? Not necessarily a bad result, but was something done that didn't follow the way things should have been done? That's the first element of consideration of any malpractice case. And the second thing is, even if something was done wrong, this is almost the more important question, is what was the result of what was done wrong? The damages, because the damages are very, very important in bringing a case. There are times that you can prove that something was done wrong, but if the damages aren't significant, then there really isn't a case, because these are very expensive cases to bring, to consider. You need experts to review, you have to get the medical records reviewed, and that's a very important part in considering if a medical malpractice case should be brought.
Is it my impression, or you who deal with medical malpractice all of the time, that many people are confused as to whether they in fact have a medical malpractice? For instance, they may feel that they went to an emergency room and wound up spending 7 hours waiting to see a doctor, or they may feel, I've heard many times, they're in a hospital, a relative or a friend or parent or whatever is having surgical procedure. As the procedure concludes and the surgeon comes out and doesn't spend very much time with them, maybe gives them a quick summary as to what transpired, how did the surgery go, which certainly they are entitled to. But they feel that those kinds of things maybe have something to do with malpractice. So I'm interested, with all of your experience, what are the kinds of areas that people tend to think are malpractice, but generally speaking do not quite make the level of a legal malpractice case?
Well, the issues you brought up, very interestingly, are things that physicians are taught by their insurance companies to avoid. In other words, insurance companies educate their insureds, their doctors, not to do things that piss off or get patients or patients' families upset. Because when patients and patients' families get upset, they try to look to see if there's a case. So, going back to my original definition of malpractice, those cases don't have injuries associated with the slight or the impropriety of the doctor. So those really wouldn't be cases. Cases where, God forbid, there are significant injuries and the doctor didn't pay the a required amount of attention, wasn't careful, and it can be shown that the doctor wasn't careful and thereby caused injury, those are the cases that you want to follow up on.
You used an expression which I believe is very important in malpractice, and that is deviation. Could you talk a little bit about that?
Okay. In most professions, and in medicine for sure, certainly, there are standards of care. things that normally should be done under almost all circumstances. For example, if somebody has an infection, the first thing that, if it's possible to culture that infection, to figure out what bacteria is causing that infection, that should be done. If there's an infection, normally an antibiotic should be given. So the standard of care in view of a suspected infection would be to do a culture if a culture can be done, and secondly, to give an antibiotic. If somebody has a suspected infection, or the doctor should suspect an infection, and doesn't do a culture when it was available to be done, and doesn't prescribe antibiotics when they were available to be prescribed, and the infection gets much worse and causes significant injury, that would be a deviation or a departure from good and accepted standards of care. To bring it to something that a lot of people do from a driving point of view, the standard of care when one's driving is to stop at a red light. If you go through a red light and you cause injury, that's negligence. If a doctor doesn't do what they're supposed to do, if they go through the red light, so to speak, that's malpractice.
I think most people have had some experience, hopefully not a serious surgical procedure medically, but there is something called informed consent. How does that figure into the issue of malpractice?
Okay. A patient has an absolute right to be informed of the reasonable alternatives to surgery, the risks and benefits of the surgery, and the possible complications of the surgery. Now, they don't have to be given a list of everything that could happen, but they have to be given enough information to make an informed decision. In New York has what's called a reasonable person standard. So in New York, even if you're not given that information, one of the questions a jury is asked is, would a reasonable person have had the procedure or the treatment or the course of treatment had they been given the proper information? So in New York, it's a tougher case to bring unless the care and treatment was such that most reasonable people would not have agreed had they been given appropriate information.
What has been your experience with regard to doctors and particularly surgeons preparing a patient for a surgical procedure? Is it your experience that most of them or almost all of them, what is your sense in terms of meet the standard of giving an informed consent? And is that supposed to be done verbally, or is that required, here, sign this piece of paper?
Well, giving somebody a piece of paper and telling them to sign it is definitely not acceptable. What I find very prevalent, in most hospitals, they have informed consent or consent to surgery forms. And if you look at it carefully under the procedure, it says the procedure should be written in lay terminology so that the person signing it knows what they're signing. The vast majority of the time, what is written by the surgeon or the surgical assistant or the nurse is something that's in medical terminology, where there's no way a patient, without looking it up, and they don't usually have the opportunity because sometimes they're signing this on the day of surgery, they don't know what procedure actually is being done. And I've found very often patients who come to me after they're injured saying, I didn't understand what was going to be done. This is what was done, and look what, I would never have agreed to that. And then you get the consent form, and it says, a foraminotomy with facetectomy and an internal cage being installed. Not too many people would understand what that means.
Yeah. Be interested in hearing maybe one or two examples of some, maybe they can be recent or ways back, medical malpractice cases, so that our viewers can get a sense as to what in fact is a malpractice case.
Well, sometimes the malpractice you find, excuse me, is shocking. I had a case recently where a woman went in and they suspected she had a condition known as lymphoma, which is a malignancy. And she had a bone marrow biopsy. In the hospital where she had the bone marrow biopsy, the doctor who was managing her felt she should go to a more skilled facility. And she transferred her patient to a more skilled facility, giving the history that a bone marrow biopsy was done but was negative. The bone marrow biopsy was positive. It showed this woman had a lymphoma. And yet, nobody ever reported it to the next hospital or to the, ultimately she went to a third hospital where they made the diagnosis, but the condition had advanced so much that the woman died. Mm-hmm. I've seen many cases where doctors have not read the reports of tests that they've ordered or performed. Those cases, to me, are very egregious and easy cases to prosecute on behalf of a family. Failure to diagnose cancer cases, very common. When somebody is diagnosed with a cancer and they're told they have stage 3 or stage 4 cancer, and they've been going to a doctor and making complaints which either should have been investigated or were investigated and showed signs that the cancer had been present. Those cases are common as well.
Why do you think that is, having been having been as a physician, and so you have great amount of experience, very unique being the lawyer physician. Why do you think that failure to diagnose occurs as frequently as it does?
Well, I haven't practiced for many years, first of all, but most physicians now have a lot of other external pressures on them. The need for documentation for insurance purposes is many times what it used to be when I was practicing decades ago. Most doctors now are practicing in where they're part of a hospital practice or a hospital-based practice, and there are all sorts of other requirements that they have. I don't think that the family doctor is viewed as caring as they were before. I don't think they're personalized with their patients as well. They are inundated with mounds of paperwork, and they're looking to make the kind of money they made before, so they have to see more patients or do more procedures, and unfortunately patients fall through the cracks, and that's what malpractice attorneys are here to stop.
One of the most frightening kinds of malpractice cases, and we hear them, and I'm interested in your observation on them, and that is associated with a birth. And obviously this can then turn into developmental disabilities for a youngster and perhaps an entire life, which, for lack of a better word, is really so reduced, if not eliminated to a great extent, even though the person may live. What are the kinds of malpractice issues related to infant births?
They're numerous. They all ultimately deal with the amount of oxygen that gets to the baby's brain. So they could be during the prenatal period before the baby's born, or they could be perinatal at or about the time of delivery. So often a C-section, a cesarean section, has to be done on an emergent basis and is not done. Mm-hmm. And if that happens, then the baby will suffer an anoxic injury, an injury of not getting oxygen to the brain, not getting blood to the brain, and the child can end up with cerebral palsy and terrible limitations to face and obstacles to face throughout life. In the prenatal period, there are other conditions which can be identified. Sometimes they can be treated, sometimes not, but they have to be understood and recognized as soon as possible to give the baby the best chance.
Talking about a birth issue and a horrible story was the case that you and I shared and were co-counsel on. And frankly, I've been surprised that we've seen other kind of cases like that, but it is maybe worth mentioning, sure, without the details, without the specifics of the names of the case, but a little bit about that case, because it's really disturbing.
This was a case where a young woman had it was her first pregnancy. She gave birth, and there was a retained placenta, a large portion of placenta which was retained. The placenta had been manually delivered after a long period of time of Pitocin, a medication that helps the uterus contract and basically get hard in order to help the baby be expelled. And so the placenta was manually delivered by the doctor, who put her hand inside the uterus in order to remove the placenta. So even though a piece of placenta can sometimes be left behind without malpractice, in this case it was definite malpractice because she should have been able to feel the difference between a soft, spongy placenta and a hard uterus. And the placenta was left behind. The poor woman who had given birth, she came back to the hospital making complaints. She was readmitted to the hospital. They never did an ultrasound. They sent her home, and then she died several days later. Yeah. Her husband woke up to see her passed away.
Yeah, it's a horrible story. And I want to ask you with regard to statute of limitations, because in many of our face-to-face series, we talk about a traditional 3-year statute of limitations. Why don't you outline what it is with regard to medical malpractice?
Well, physicians were able to limit the statute of limitations to 2.5 years through the legislature. So lawyers are working, actually help the physicians by shortening the statute of limitations. There is some talk now of extending it based upon discovery, which I'll talk about in a second. The statute of limitations runs from the date of malpractice, the 2.5 years. So if there is malpractice, a lawsuit has to be started within 2.5 years, even if the person who suffered an injury didn't know about it. So, for instance, I had a case where a woman went to a hospital, had complaints of coughing. They took a chest x-ray, and they found what they thought was a neoplastic lesion in her lung. They found on the chest x-ray what they thought was cancer. Nobody told her. Mm-hmm. She came back to the hospital 2 years and 5 months later. They asked her when she came to the emergency room, after they admitted her, why didn't you treat your lungs? She said, nobody ever told me anything. Mm-hmm. By this time, the lung cancer had spread. She died several months later. But when we went to bring a lawsuit, the two treatments are not considered continuous care. It was a 2.5 year gap. Mm. So the malpractice relating to the initial failure to tell her that she had cancer that they knew about was outside of the statute of limitations. We were very lucky in that case because there is a small loophole, so to speak. When a malpractice case can be brought without an expert, when the negligence is so obvious that anybody could recognize it, then it's a negligence case. Okay. So it was a 3-year statute of limitations, and we were able to bring that case. Yeah. But now it's being considered that the statute of limitations will start to run from the date of discovery, as in many states, many jurisdictions have that, which is much fairer, because if somebody's injured and doesn't know it, if somebody has an undiagnosed cancer and finds out 2.5 years after treatment, why should that absolve a physician who made a grievous error?
I want to ask you about the issue of a medical malpractice suit is commenced as a result of some treatment, let's call it in a hospital, and the patient winds up dying. What happens? Are you still able to do something with a case like that?
Absolutely. The first step in a case like that is going to the surrogates court and having a point person, somebody from the family usually, designated as the administrator or the administratrix, executor or executrix of the estate. And that person can then bring the lawsuit in standing as the person representing the estate. And it's something that we do regularly. I have one person in my office she does primarily that and works with all the surrogates courts in all the boroughs.
I just wanted to point out that we have our question and answer brochure in English and in Spanish with a nice picture of Attorney Elliot Wolf, incidentally. And these are questions and answers in very basic, simple layman's language, and we are happy to make these available to you anytime. Feel free just to give us a call, and we're happy to provide this. One final thing that I did think was of some importance, because when speaking about hospitals, there are hospitals run by the city of New York, and there's generally about 3 or so in each of the boroughs. And I'm just going to take a moment to read them, and then maybe you can finally give an explanation of what happens if someone has a medical malpractice case from a hospital in the city of New York. In Manhattan, the 3 major city hospitals are Bellevue, Harlem, and Metropolitan Hospital on the east side on 96th Street. In the Bronx, the 3 are Jacoby Hospital, Lincoln Hospital on 149th Street, and North Central Hospital near Gun Hill Road. Notice I'm from the Bronx, so I'm a little more familiar with those exact locations. And in Brooklyn, the 3 hospitals are Coney Island, Kings County, and Woodhull. And in Queens, it's Elmhurst and Queens Hospital. And in Staten Island, it's the Seaview Hospital. So those are the hospitals. And if there is a medical malpractice injury and potential lawsuit, there is a slight modification with regard to the 2.5 years. And why don't I, as your last question, if I may, why don't you just summarize that?
It's more than a slight difference. You have to file what's called a notice of claim. You have to put the city on notice, and there are very specific requirements that of that notice. It has to be done within 90 days of the care and treatment that is being alleged to have been malpractice, unless it's of an infant. The 90 days to put them on notice, then the city has a right to question in what's called a 50H hearing the person who's making the allegations, and then the lawsuit has to be started within 1 year and 90 days after the malpractice. With children, there's an extension, a delay, and you could also try to extend the 90 days to 1 year and 90 days by going to the court and showing them the reason why, in the interest of justice, it should be 1 year and 90 days.
Elliot, thank you so much. Hope that you enjoyed, and there was an awful lot that you heard with regard to the topic of medical malpractice, and rightfully so. It is, as I said at the outset, a topical area, not only that we practice in co-counsel with Elliot, but also it is the question that majority of people that ask us about legal issues and legal cases talk about. So hope this was informative for you. And again, thanks for watching. Thank you, Elliot.
Thanks, John.
Good.